again. My name is Tanisha St. Price, and I am an attorney in West Hartford, Connecticut. I have my own general practice in which I specialize in real estate, family. I do a lot of contracts, landlord-tenant law, family law. So I just a gamut, and I was asked today to come and discuss contracts with you guys. So that's what we're gonna spend the rest of our evening discussing contracts. Okay. Now, when you think of contracts, what do you guys think about? What do you interpret and what do you think a contract is?
A working agreement between two people or two entities.
A working agreement. Okay, anybody else? What does that working agreement consist of? How do we get to that working agreement? Do you know?
You have a party that has a goods or service they're offering, and another party who would like to utilize it.
Okay, that's a pretty good example. Before we get in, I'll give you the definition of a contract. And a contract is a promise or a set of promises, basically, for which the law gives a remedy. And what that means is a promise for a promise. I promise to buy your goods or services. You promise to pay for, I promise to buy your goods or services. You promise to sell them to me. So it's a promise for a promise. That basically is where we get to our contract. Before we get to that, though, I want to just talk a little bit about the applicable law and what governs contracts. In Connecticut, there are two types of laws that govern our contracts, and one is common law, and that's just regular state law, case law, and the other is what we call the Uniform Commercial Code, Article 2, and that is...
Do you have a paper on the...
Oh, sure. There you go.
Okay, thank you.
You're welcome. In the Uniform Commercial Code, basically governs the contract for sale of goods. So there's two separate, if you have a contract for the sale of goods, you'll be looking to the Uniform Commercial Code. If you have a contract for services and basically services, then that is where we look to the common law, which is the state law. Any questions so far?
What if it's a combination of the two?
Right. Well, if it's a combination of the two, what the courts look at is what is the dominant, and we're going to get to that. But what's germane to the contract? What's the dominant basic aspect of the contract? For instance, and I have an example in there that we'll get to. But for instance, if I'm selling cookbooks, and I say I have cookbooks for sale, $25 for cookbooks, and with the purchase of your cookbook, you get a free cooking class. Now, the class is services, and the cookbooks are goods. So the basic element of that contract, offer and acceptance of is the cookbooks. So the court will deem that to be a sale of goods, so it will be governed under UCC Article 2, which is the sale of goods. So. Okay, so basically contract formation, we're going to discuss how do we form a contract. In order to form a contract, forgetting I have this thing here. Okay, to form a contract, you have to have an offer. So you have to have someone that is offering something, goods or services, and once you see that there's an offer, there has to be an acceptance. So the initial communication is the offer. I'm offering to sell my car for $50, and then there has to be an acceptance. There has to be someone to accept that offer. And once that offer is accepted, then you move on to what's called consideration. And a consideration is the value, the money in this case, that is exchanged, the monetary exchange for the car that I'm selling. You also have to have mutual assent. And what mutual assent means is that there has to be an agreement on the terms of other parties. Both parties have to be on the same page. We have to mutually agree and mutually understand what's going on. And then there's capacity. All of these elements are necessary to create a legally binding contract. Both parties have to have legal capacity, meaning they have to be over the age of 18, they cannot be intoxicated, and they cannot have any mental incapacity, so they, yes.
Okay, on that issue there, if you're going into a contract and you're given services or providing services, would one person be, could claim themselves to be the hierarchy, or or would it be that they would be on equal standing?
In terms of forming the contract?
Yeah.
Well, there really isn't, in terms of the contract formation, there's not anyone who's hierarchy or whoever, you know, one is the lower on the totem pole, so to speak. Both parties basically have equal responsibility in order.
Okay.
They have to be mutual agreement here. So
Okay.
in terms of a contract, there's really no party that is higher than the other party. We both have to have an obligation under that contract for it to be a legally binding contract.
Okay.
Whether it's a promise for a promise or a promise for an act, which we'll get into, so that's a bilateral or a unilateral contract, there's still, both of us have to perform. We have to do something in order for us to have that legally binding contract.
Okay.
But a contract is only good, you know, when I say that, let me, as I'm thinking about what you're asking, there could be a contract that is one-sided to where one person is getting more of the benefit than the other party. But again, that's where you come to the mutual assent. If you agree to that, you get what you get. If you say, yes, I agree to buy your $1 million home for $2 million, then, and if you agree to that and that's in writing and there's mutual assent, then that's the contract, and that's the benefit that you get buying a $100 million house for $2 million.
Okay.
So basically, there could be someone who the contract doesn't benefit as much as the other, but again, once you agree to that contract, once you understand the terms of the contract, whether it's beneficial to you or not, if you understand it and you agree and you accept the offer that the other person is extended, then there is there's a binding contract.
But you don't have to accept it.
No, you don't have to accept the contract.
Okay.
It only becomes a contract once it's accepted. It's a mere offer prior to an acceptance.
Okay.
Just like you put your house on the market and people shop around and then you get an offer for the sale of your home. So say you have your house on the market for $150,000, someone comes and put an offer on your house for $148,000. You don't like that offer. You don't accept it, you don't sign it, you don't accept the offer that they've extended to you, and it doesn't become a contract. It only becomes a contract when there's two or more parties that are either signed their agreement or on, and we'll come to later on to realize that all contracts doesn't have to be in writing either. So we'll get to that point, but yes, it will not become a contract until there's an offer and someone has accepted that offer. And then all of these elements are basically present in order for it to be a legally binding contract. So with capacity, once again, they have to be of the age of majority, so over 18, not intoxicated, and have the mental capacity to do so.
Okay.
Legality, the subject matter that the contract is entailing has to be legal. The classic example that is given in law school is basically services, a service contract for a prostitute. So the pimp goes and pays the prostitute, she doesn't perform. He can't now go to the police and say, she didn't give me what I paid for, because those services are illegal. So you cannot contract for illegal services, it will not be enforceable. That's just like, you know, the purchase illegal drugs, and I paid for the drugs, they didn't give me the drugs. I can't now go to the police or the authorities and say, please, or even the court and say, please enforce this contract, because the basis of the contract was illegal. The drug sale was illegal. The services for the example of the prostitute was illegal. So you cannot enforce a contract where there are terms of it on its face is illegal. You look like you have a question.
No.
Okay. I thought that's just the easiest way. I mean, that's the classic example in law school. The easiest way to paint the picture of you cannot have a contract based when the goods or services are illegal. And in writing, it's not, all contracts do not have to be in writing. It's not a necessity, it's the necessity of form, but all contracts do not have to be in writing, and we'll get into which contracts do and do not have to be in writing. But it is highly, highly recommended that all contracts be in writing. because it becomes extremely difficult when they are not in writing for a court to enforce an oral contract, because the terms are not there. You could think one thing or say one thing and the other party would think or say the other, so it's always recommended that, while it's not necessary, but it is always recommended that the contract be in writing. Contract formation. There are bilateral contracts and unilateral contracts. In a bilateral contract, each party exchanges a promise for a promise. Like I explained earlier, I'm promising to purchase your car for $100. You're promising to sell the car to me for $100. So that's a promise for a promise. That creates a contract. Example, and I think I just put another example. Seller promises to sell Blackacre to buyer for $10,000, and buyer promises to purchase Blackacre for that price. That's a promise for a promise. There are two promises that makes a bilateral contract. And the acceptance is with the return, with the promise in return, not an act. Then we go to unilateral contract, where it does not involve an exchange of promises. It's only one party makes the promise and the other party is required to do an act in return. So example, Susan promises to pay Charles $5 if he will deliver a textbook to Rick. Charles is not obligated, that's just an offer. I'm promising to pay you $5 if you deliver this textbook to Rick. Charles is not obligated to deliver the textbook, but if he does deliver the textbook, that's the act. If he delivers it, then Susan is obligated to pay him that $5, because that is his way of showing acceptance in a unilateral contract. So I'm telling you, I promise to pay you if you deliver the book. You don't have to deliver it, you just won't get the money. But if you deliver it, you have now accepted my offer, which made it a contract, and now I'm obligated to pay you that $5. So it's an acceptance with an act. Contracts are frequently described as express, implied, and quasi. An express contract is formed by language, whether it's oral or written. The terms are expressly defined. They are definite. They're very specific. Each party knows the terms and conditions of the contract. Usually it's in writing. I know what my responsibilities are. You know what your responsibilities are. We know what the end result is supposed to be. That's an express contract.
So how do you enforce the oral agreement?
An oral agreement, for instance, is sometimes a month-to-month lease, for example. As long as the lease is not over a year, it's a month-to-month, it can be orally. And so basically I will enforce it through the courts. If I say you can rent my apartment for $1,000 a month, you agree, you go to the apartment, you rent it, you've been paying me $1,000 a month, 1 or 2 months you stop paying. So then I go to the court and I say we had an oral agreement, a verbal agreement that he would rent my apartment for $1,000, he's been paying my $1,000, he stopped paying midway, I'm enforcing the contract. So the courts will enforce that because it is my unit, you are living there, you are renting it, and they will enforce that oral contract. And it does sometimes become difficult to enforce oral contracts because, again, we'll get into what's called the statute of frauds, and where you can have an oral contract for if the goods or services are less than $500, you don't have to enter into a written contract. Most contracts need to be in writing or should be in writing, but all don't. It does become a little bit more difficult to enforce or to enforce an oral contract. When you go to court, the judge it's basically up to the judge. They will hear your side, they will hear my side, and determine what the terms are of the contract. Basically, it's always important, and I always advise clients to do a contract, a written agreement, because what the courts do with written agreements are what they call, say for instance, this is the contract, and all the terms are expressly defined in the contract. The court will look to that contract, and your interpretation may be different from my interpretation, and the court will go by what they call the four corners rule. What's written within the four corners of that contract, they will interpret it and they will enforce it therewith. It is a little bit harder to basically enforce an oral. I mean, you have to have witnesses. I heard them say that, and it's a little bit more complicated, but it is basic. You can form a contract based on a verbal agreement.
What do you, on leases, can it go over 12 months and still be oral?
Well, the initial term it can't be over 12 months. It can extend past 12 months. What usually happens with a lease is called month to month. So the contract, when it's an oral contract, it's a month to month. So it's on a monthly basis, it's not a year. We can do that for a year or 2 years or 3 years, but the contract is a month to month contract that just keeps getting extended. So say for instance, it's from May 1st to May 31st, that contract ends May 31st and then it goes from June 1st to June 31st, that contract ends on June 1st. It does get extended, and every month it's a new contract, basically.
And what if you have a tenant that you send a new lease to with a raise in rent? They won't sign the lease, but they give you the new rents. How is the wording in that new lease interpreted?
It's not, because it's not a contract between you and the tenant, because the tenant didn't sign it. So the wording in that lease is not binding.
Would it if I have a previous signed lease, would it revert back to the wording of that lease?
No, not necessarily. Not necessarily, because once that lease expires, it's gone, it's over. That unless you renew the lease. Sometimes in that lease it will say after the initial term, this lease, if the parties haven't entered into another written agreement, this lease will become a month to month, and the terms therewith will govern. That, so to speak, the court can look at it at that. But after that, when there's no writing and it's just a month to month, there's no writing really that the court will look at.
So if your previous lease says that it can go to month to month as part of that original lease, but the rental amount changes, is it still applicable to that previous lease?
The court will not. The court will, it's a case-by-case basis, and is based on the evidence, whatever the case is before the court, whatever the subject matter. I don't know if it's you say that the lease expired, I want them out, or the rent went up. If it's not in writing, then if your tenant has been paying the higher rent, it's obvious that you can show that the tenant has been paying that higher rent. So the court will go by, okay, you've been paying $900 for the past 6 months, so we've established that the rent is $900. And then if there's something in this lease agreement where it says that, no parking in the garage, and the lease expired and the tenant began to park in the garage, and you say you can't park there, I don't want you to park there. Well, really, the written lease is it's circumstantial evidence, you can use it as such, but it's not a contract, whereas you can say they're breaching this contract because that one is expired and they didn't enter into a new one.
Yeah.
An implied contract is formed by manifestations or assent other than written or oral. It's your conduct. For example, you go to a beauty salon or hairdresser or barbershop and you sit down in the barber's chair, you don't say anything, the barber says nothing, the barber cuts your hair, and you sit there and let the barber cut your hair. Is that a contract? It is. It's a contract. Now you have to pay for that haircut. Your actions, your conduct assented to that contract. I sat there, you cut my hair, and I can't just walk away now and say, I'm not going to pay you because I didn't tell you you can do that. I sat there and I allowed you to do that. So my conduct bound myself into that contract. So now I'm on the hook for that haircut or those salon services. A quasi-contract is really not a contract at all. What the courts do, and that's kind of somewhat what you're saying, in a quasi-contract, it's usually when the courts now are brought into the situation and they try to construct a contract so that if there's nothing in writing, that one party is not unjustly enriched, or that it promotes fairness and prevents injustice, so that you don't, I don't benefit from your misfortune. If it's like a gross mistake or emergency aid, a doctor renders aid to you, you're basically, you're dying and they have to render emergency aid to you. well, no, you didn't give that doctor consent, but yes, you are on the hook. They will send you a bill and you are responsible for paying that bill. And just stop me at any time with any questions. The first step of an agreement, of the agreement process, is there an offer? How do we know if there's an offer? An offer is a manifestation of an intention to be bound. So the offer, I'm offering something, I have an intent to be bound by whatever it is that I'm offering. The terms have to be definite and specific when I make that offer. And there was a lot of issue over whether an advertisement is an offer. Do we think an advertisement? So if I'm advertising IHOP, advertising to sell breakfast, I'll say it's an incredible offer. Breakfast special for $2.49. Is that an offer for a contract?
Yeah,
Why?
because they offered it, and they gotta keep, it's almost like your word,
Okay.
you know what I mean?
So if I advertise a breakfast special for $2.49, we agree that that's an offer? It's not.
No?
No, it's a solicitation. Because remember, the terms have to be definite and specific. Am I offering one breakfast, two breakfasts? What is the breakfast?
Oh,
Is it
okay.
sausage? Is it eggs? Is it pancakes? We don't know. So it's basically what they call a solicitation or preliminary negotiation. Because I can show up and pay $2.49 for a slice of bread, and they say that was our breakfast special. So the terms are not definitive.
But most of those ads are more specific as what they include.
Sometimes, not all the time.
No, but most of the time.
Because even if they say I'm selling a television, I'm selling, TVs for sale. We don't, what's the make, what's the model of the TV? How many TVs? Because there was a case where the huge Black Friday, the advertisement says we have,
55-inch for $200.
right. But then you get there, they have 155. It was to lure the people in. So you got 1 million people trying to go find that 155-inch TV. And so the court says, you know what? They're saying this is not a contract.
Advertisement, but it has happened, because I remember, about 10 years ago, Best Buy said something like that they had TV, and it was, people stayed there all night.
For 5 TVs.
And when you got there,
Yep, the inventory is very slim, very limited. Now they have to be much more specific, and you'll see in the fine print, they'll say quantities limited to like 20 per store or 10 per store, so that they will, people will know, listen, this is what you come, if you're number 30 in line, we only have 20 in this store. So that's how specific and definite the terms have to be in order for it to be an actual offer. Once we've established that we have an offer, now we have to establish, was there acceptance? Was the contract revoked, the offer revoked before there was an acceptance of the offer? Or let me back up. If the contract was revoked, or if the contract was rejected. So let's discuss revocation or termination first. An offer lapses after a stated term. So if I say this is only applicable, or this offer only lasts until May 5th of 2014, or they just give you, or 5 hours, or 1 week, a specific stated term, and the offer terminates after that. So you can't go and say, listen, if I say I have a car for sale for $25, good through June 1st. You come on June 2nd and say, well, this is your advertisement. You said, this is what you offered. You offered me to buy this car for $25. And I say it was only good until June 1st. So June 2nd now, you can't accept the offer because it's too late. The offer was terminated. Or if I say on March 1st, I made an offer to sell my car for $25. And you come back on October 1st and say, okay, I accept your offer. Well, the offer terminated for what we call reasonable time has passed. The courts do not distinguish or have not interpreted what a reasonable period of time is, but we know from March to October, that would be pretty much a reasonable period of time that had lapsed where we can say that offer is off the table. Revocation. An offer terminates when the offeror, that's the person making the offer, revokes the offer. So if I make an offer and then I revoke it, I say, sorry, I changed my mind, that offer is terminated. But it has to be revoked before someone accepts it. So they can't accept, I can't say, okay, I'm gonna sell my car for $25, and then the next day you say, okay, I'm gonna accept that offer, and then the day after that say, I revoke my offer. It's too late. Once you accept, it's a contract. And I can't revoke it after acceptance is made. I can revoke my offer prior to someone accepting it, but not before. There's what we call a direct revocation, where the offeree is told directly that the offer is revoked. So I offered to sell my car when I came in here, and no one accepted. But by the time I leave, I said, you know what, guys, I changed my mind. I'm taking that offer off the table. And I directly informed you all that my offer is off the table. So tomorrow, or when I get home, you can't call me and say, I want to accept your offer. You can't force me to do it now because I informed you directly that I revoked my offer. I took it off the table. I changed my mind. There's also an indirect revocation, where the offeror engages in conduct that indicates he or she changed their mind. So I offered to sell my car to you, you haven't accepted yet, and I sell my car to Susie. Well, indirectly, you know that the offer's off the table, because if Susie comes to you and say, oh, I bought Tanisha's car, well, you know the offer is revoked, because my conduct indicated that I revoked it, and you were informed because Susie made you aware that Susie bought my car. How do you reject an offer? Do we know how to reject an offer?
Well, it said that I don't want to, well, say for instance, like I'm in kind of a contract and
Well, once you're in the contract, you can't reject it. It's the contract. But if you're negotiating, right. But if somebody extended an offer to you, how do you reject it? One simple way is to say, nope, no thank you, I don't want to. That's a rejection.
Okay.
What people don't realize too is a rejection is, and I'll go back to the real estate example where I list my house for $150,000. Someone comes and says, I'll pay $145,000. Well, you've rejected my offer. That's considered a counter offer. If you don't accept the terms of my offer, you have now given me a counter offer with something less. That's a rejection. So you basically rejected my offer. So if you said, okay, here's my counter offer, $145, I've become you've made me an offer. So now I'm the one who can accept it in order to make it a contract. So the parties have changed. But if you make a counter offer to someone, you've essentially rejected their offer. So they're no longer obligated. You didn't accept it, though on the face, your acceptance didn't mirror the offer, what we call the mirror image rule. Your acceptance did not mirror what the offer was, so now that's a counter offer, and that is also considered to be a rejection of the initial offer.
What about a situation where somebody offered a house for $150 and you offer $160, they don't accept it?
It's a counter offer still.
If you offered more,
Doesn't matter. It still does not mirror the offer. There could be a reason I don't want to take $160. A, the house is not worth $160, and if you're getting a mortgage, the mortgage company may not give you the mortgage for $160, and then there's the whole, you may have to terminate the contract because you can't get enough money to borrow to buy the house anyway. But it's still considered a counter offer even if you offer more. They can accept it if they want to accept it, but they can also reject it because it's considered a counter offer. Death of a partner. I'm sorry.
What if you offered $150? They offered them $150. You accept $150, and somebody else offered them $160, and they don't take your offer, even though it mirrored. How's that looked at?
They didn't accept it, so it's not a contract.
But you accepted their exact term.
Right. You accepted their exact, so if they're making a specific offer to you.
Yeah. And you accept it.
Mm-hmm. And once you accept it, it's a contract, and that's it. That's it.
But they have an offer for somebody else for 10,000 more.
But remember, I'm the one making the offer, and you're accepting my offer.
Yeah.
So it's a contract. That's it.
Is that all verbal?
No, it's written. It's anything. It's written or verbal.
Oh, okay.
But if we're talking about real estate here, I'm listing my house for $150. The buyers that come along, they're the ones that's the offeror now in that instance, because I'm making you an offer. So I'm the one who's listing and selling my house. I have it on for $150. You give me the $150 and I accept, it's a contract. However, you are now making me an offer. So if you're making me an offer, she's making me an offer. I can accept whose ever offer that I want to. The minute I accept an offer, then that becomes a binding contract.
So it's very hairy there. Somebody makes an offer, you accept the exact terms, they don't have to accept it.
No.
It's not a contract.
No.
Even though you accepted their exact terms, you don't have a contract.
No. And in real estate, we have to it's a little bit different in real estate, but you have to think when I'm listing my home. But so I'm just listing it and telling the world at large, make me an offer. So there's many people that are coming that are making me an offer, and I can say, nope, I don't want your offer, nope, I don't want your offer, yep, I'll take your offer. And as soon as I accept, that's a legally binding contract, all of the offers are off the table. Death of a party does before acceptance. It doesn't automatically terminate the contract. It terminates a revocable contract, a contract that can be revoked. So if there was an offer of acceptance, the party's not here anymore, so you can't enforce the contract. However, there are irrevocable contracts that death does not terminate the contract. For instance, if I wanted to buy your car and I gave you a deposit, or I put an option, I gave what we call an option, and I said, here you go, this is for you to take that car off the market, to sell it to nobody else. Here's my deposit. And you pass away, your estate now has to sell me that car, because that's an irrevocable contract. However, if there's no option, like an option, a money deposit or something, if there's nothing of that nature, then the promise for a promise, a bilateral or regular unilateral contract, it can be terminated. But an irrevocable contract cannot. So then that contract, and it's not, that contract can be pursued against your estate. If it's a company, the contract, if it's an LLC, that company that you own, the contract will be enforceable against your successors and your heirs. Now we discuss, has this offer been accepted? The language of the offer controls the acceptance. For example, an email states, Stan, you can accept this offer only by reporting to work. Stan emails back, I accept. The result, no offer. Why is it no offer?
He didn't report to work.
He didn't report to work. You can't accept it by saying I accept. That's the language of the offer controls the acceptance. So if I say you have to accept this by coming to work, if you don't come to work, you didn't accept. You can't just email me back and say I accept your offer. Sorry, the acceptance was you have to come into work. Starting performance in a bilateral contract, which is a promise for a promise, is acceptance. So if I promise to rake your leaves and you promise to pay me to rake the leaves and I start raking the leaves, then that's an acceptance. That's a bilateral contract. Jim offers me $5,000 to paint his house. I start painting. The results, that's an offer. The offer does not specify how I am to accept. It didn't say I have to accept by breaking the leaves. It didn't say I have to accept by doing something different. It didn't tell me, so I started it, and now that was my acceptance to you. Starting performance in a unilateral contract is not accepted. You have to complete the performance in order to accept it. So it's a promise for an act. So if I just start the act and didn't finish it, I have not accepted your offer. It's not, starting performance is not acceptance. I have to complete it. There's something called the mailbox rule, and that means that rule is that the acceptance of the offer is effective when the acceptance is mailed. And it protects the person, the offeree, the person who's doing the accepting from revocation when they have already mailed the acceptance. And for example, on May 7th, an actor gets a letter in the mail that says, you'll get $5,000 for a role in this new film. May 8th, he mails back the letter and says, I accept, I want this. And then May 9th, he gets a letter revoking the offer. The result is his offer was accepted the minute he dropped it in the mailbox. If he didn't get the revocation before he put it in the mailbox, whether or not they mailed it to him prior to him mailing his, the minute he put it in and did not receive a revocation, that becomes a contract. You can't revoke it after they mailed it. That becomes the acceptance, and it is an enforceable contract. We discussed earlier about lack of capacity to make these contracts legally enforceable. And again, minors, intoxicated persons, and mentally incompetent persons are not, their contracts, what we call voidable, or they do not have the legal capacity to enter into a contract. Now that doesn't mean that a 17-year-old can't go to a dealership and the dealership sells him a car and he pays for the car and goes off the lot. 6 months later, if he's still 17 and he says, I don't want this car, I changed my mind. Even though he rode that car for 6 months, guess what? That was a voidable contract. The dealer has to take that contract back because he entered into a contract with a minor. It's not enforceable. So that minor drove around that car for 6 months before he turned 18. He said, here you go, I don't want it. Guess what? You should have never made a deal with a minor. I don't care what kind of contract it is. It is a voidable contract. I don't care if they paid you and took the goods and ate the goods and the goods are gone and they come back and say, sorry, I don't want this. I don't need this. Or destroyed the goods. If he destroyed that car and took it back and said, I don't want this car, guess what? I mean, that's when the court gets into unjust enrichment, but at the same time, you enter into a contract with the minor, and that's a voidable contract.
Now, can the minor bring it back anytime before he's 18 or even after he's 18?
Okay. If he kept it after he was 18, then that says that he basically assented to that contract. He kind of ratified that contract after reaching the age of majority, even though it was entered into when he was a minor. If after he reached the age of majority, he kept riding around for 6 months to a year after, he cannot now go back and say, because he ratified, he put his stamp of approval on that contract by keeping that vehicle after he reached the age of majority.
Now, is the word intoxicated by the courts the same as under the influence of drugs?
Mm-hmm. It can be the influence of drugs, alcohol, prescription medication. It can be. However, incapacitated parties such as minors and intoxicated people and mentally incompetent, they're still liable for necessaries, meaning food, clothing, shelter, medical care. So if they rented, a 17-year-old rented an apartment and say, I changed my mind, I don't want that. Well, that's shelter, that's a necessary. The courts say, sorry, you have to, when you can't, that contract is not voidable. They are liable for necessaries. If they purchase food, you served me, you sold me food, I'm only 17 years old, you shouldn't have sold me those goods. That's a necessary, so that they are liable for those. Economic duress is another exception, and it's rarely a defense. One of the example is, for instance, I'm buying Met caps. I'm a vendor, and I have this huge, game. I'm supplying these caps to the Mets. I'm selling my caps at a Mets game, and my seller is selling me caps for $1,000. Excuse me, 1,000 caps, and I put a dollar sign, but 1,000 caps for $50, and that was the agreement. Well, last minute, the seller says, sorry, I can't get you 1,000 caps for $50. I can get you 1,000 caps for $75.99. And I agree reluctantly because my event is tomorrow, I need those caps, and he's the only one that has them. So that's what we call economic duress. He was the only one that has them, he changed the terms, I did agree, but because I needed them right away, and that seller was the only person that can supply them to me. So that is considered economic, an economic duress defense, which is almost never used. Misunderstanding, we had a misunderstanding on the terms of the contract. We both were not, you thought it was one thing, for instance, they used the ship, I say, my shipment will be on the ship, the Peerless. Well, Peerless is sailing in July and in May. I thought it was the May shipment, you thought it was the July shipment. We both are just talking about the same boat, but different months, so that's a misunderstanding. Mutual mistake about a material fact. A agrees to sell a bike to B. Neither A or B was aware that the bike was destroyed last night in the fire. Well, B is not bound to buy that bike anymore because it's destroyed. And there was that's the material element of the contract, is the bicycle. So B is not obligated to purchase, even though he agreed to purchase the bike, he doesn't have to anymore because of the mutual mistake about a material fact. And then there's public policy, which is also an exception. A covenant not to compete. That can be in a contract, and it can be written. What happened is the courts say they will invalidate a covenant not to compete or narrow it so that it does not operate as a restraint of trade. And for example, you'll see in a lot of employment contracts for professionals, you can't, if you're a doctor and you sign with your company, with the hospital, etc., they'll say you can't come once you leave here. You were terminated if you leave. You can't you can't work within a 10-mile radius of our hospital. And if the radius is too far, they can't say a 50-mile radius, and they can't say for 5 years, because now you're basically limiting my ability to earn a living. So they will narrow it. You can say you can't compete within 10 miles for the next year or two. The courts typically deem that to be an okay limitation on a covenant not to compete. But it can't be something that is really outrageous. You cannot compete within 100 miles of here for the next 10 years. Because I live here in Connecticut, 100 miles, you're putting me all the way into New York. For 10 years, I can't earn a living. And so the courts say that will not be upheld. That's for public policy reasons. They will not enforce a covenant not to compete that is that broad. They will either terminate it altogether or they will narrow it down. When is a writing required? Most oral contracts are enforceable, however, certain kinds of contracts need to be in writing to be enforced, and that means they have to be within what we call the statute of frauds. The statute of frauds is a statute that requires certain types of contracts to be in writing. For one, the transfer of interest in real estate. If you're purchasing or selling a home, that must be in writing. If it's not in writing, it's an unenforceable contract. You cannot sell real estate without it being in writing. If the performance cannot be completed within 1 year, then it has to be in writing. So if it's a building contract and you know it's going to take you 3 years to erect this humongous building, then that must be in writing. However, if the performance can theoretically be performed within 1 year, then it doesn't have to be in writing. So if I'm just building a garage for you, a small garage, and I say it's going to take me 6 months to build that garage, then it doesn't have to be in writing. Well, I shouldn't even use garage because that's home improvements, but which does need to be in writing. But if you're doing if the performance can be completed or theoretically can be completed within a year, then it doesn't have to be in writing. That doesn't mean that if it went over a year that it's unenforceable, because theoretically if this could be done within that year, whether the weather or some kind of complications prolonged it to go past the year, then it will still be enforceable. The sale of goods for $500 or more must be in writing. So if you have any contract for the sale of goods that is for more than $500, it has to be in writing to be enforceable. Otherwise, it's in violation of the statute of frauds, and the court will not enforce it. A surety ship. which is a promise to answer for the debt of another, a cosigner basically. That has to be in writing. So if I say, oh, if John doesn't pay, you know, if he doesn't pay you the $100 that he owes you for fixing his garage, I'll pay you. Well, guess what? That has to be in writing, because if it's not in writing, the court is not, because your contract is with John, it's not with me. I'm just gratuitously saying, hey, if you don't do it, then I'll do it, which is considered a suretyship. That has to be in writing. Or if someone co-signed for a vehicle or a house for you, that obviously will need to be in writing as well. A contract modification, if you have a verbal contract and it doesn't fall within the statute of frauds, you don't need a writing for it. If the modification falls within the statute of frauds, whether it's gonna be for goods over the sale of goods for over $500 or sale of real estate, if that modifications put you within the statute of fraud, even though the original contract did not, then that has to be in writing also. The rules of contract law governs many different types of contracts. So this is just a scope, a general of what creates a contract, how do we form a contract, how is a contract accepted, how is it rejected, how is it revoked. Those apply to employment contracts, construction contracts, installment contracts, contracts for the sale of land, for the sale of goods, manufacturing contracts, lease agreements. These general rules, and again they're general, there's a huge spectrum in terms of contract law, but just to try to give you a basic understanding of what an offer is, how can it be accepted, and what the elements of a binding legally enforceable contract are, it applies to all of these. So if you have your own business and you hire an employee, that employee, you fill out an employment contract, that's governed by these rules. If you have an employee who's just going to be an independent contractor just for one project that they may be working on, that requires a contract as well. You know, that falls within contract law. Any questions at all?
So the bigger the contract, the more you might have to get a lawyer or something, right?
Absolutely.
I mean, I'm just talking about big one. I'm not talking about $500. I'm talking about some major stuff. Selling a house or just major. You know.
Absolutely, because you need to know what your term, what the obligation is for you under the
Right,
contract.
yeah.
Because what we don't get into here, but is breach of contract. What happens when you breach the contract?
Yeah.
In that contract, it will tell, it could be liquidated damages, it can be specific performance, whereby the court says, okay, you entered into this and you said, I don't want to do this anymore.
Yeah.
Breaching sometimes not only means just paying money, it could mean specific performance in the interest of real estate. I don't want to buy this house no more. You selling your house, you said, look, you offered, I accept it, we have a contract, you're gonna buy this house. So I changed my mind. Guess what, you can go to court and show them this contract, and you know what the court can do? The court can force you to buy that house,
Yeah.
because they can enforce that contract. So it's specific performance, and so those are the things that you need to know when entering into a contract. It's not so easy. Some people think, oh, I gave a deposit, I'll just lose my $1,000, $2,000 deposit and I'll move on. Typically, that's what happens, but sometimes it's not what happens. The seller says, listen, you're gonna buy this house because I have another house that I'm contracted into buy, and if you breach this, then I'm gonna breach that contract. So, you know, it's a snowball effect. And so it is important, because the terms are very important, that you know what you are legally binding yourself when you're in the contract. And obviously the more difficult the subject matter, or the more in-depth, or the higher the value of the contract, what, you know, the monies that are involved, it definitely will benefit you to get an attorney. And also, you get what you bargain for. Whether you bargain for good or bad, if you sign that contract and the bargain is not beneficial to you, you are going. That's what you agree to. So whether a good bargain or a bad bargain, once you accept that contract, that's your bargain and it's your obligation.
Are there any good sources out there for us to look for boilerplate contracts and different subjects?
There is the Westlaw has, and these things are, they are boilerplate, but you have to understand the terms that they're really technical, so there could be a boilerplate like Westlaw has a book of forms. You can Google Westlaw, and they'll have, like, in Connecticut, they have a book of forms. Almost every contract you can think of, they'll have, whether it's a lease agreement, whatever it is they may have. And some people, they will get that and just fill in the blanks, but don't understand the remaining language that, yeah, I fill in the blank, I'm the buyer, he's the seller, I'm this. And there's a lot of language in there that they don't really understand what the language is. I just know this is a contract. I know I just saved myself some money from a lawyer, and then when it goes downhill, sometimes it's good and sometimes it can get ugly and it can go downhill, and then you have to get a lawyer to do what we call damage control, because now we have to pick up the pieces and figure out how we can help with, you know, 'cause sometimes people don't realize the terms are not beneficial
Does
to them.
Westlaw's products, are they normally legalese or more user-friendly language?
More legalese.
So,
I'm not sure of, I mean, there was a company, I'm trying to think of their name. It was like a stand, and you can go to like a stationery store, and they'll sell different contracts, and you go online, they have companies, but the problem is some of those companies are not lawyers that are doing those contracts too, so it'll be boilerplate, simple language, and then you have to worry about whether or not that contract applies to your state, to your jurisdiction, because certain states have certain laws that, you know, that contract may be good in California, but not good in Connecticut. But they are, if you Google it, there are tons of boilerplate language, but if you're looking for a reputable one, and within our state, I know Westlaw has some, and there's a lot of different companies here. I'm just trying to think of that, I can see it, but I can't put my finger on the name of the company that actually does it. But there's Blumberg Law, and they sell a lot of contracts specific to states. If you just tell them what state you're in, and they'll sell you, they'll print up a whole contract, you just fill in, they'll say, you know, they'll ask you for specific information, you fill it in, and they input that into the contract, and then at the end, you purchase the contract specific to your situation.
But yeah, I think you're playing a dangerous game though, with that. You know, I mean, like you say, there's language in there you don't understand, easy as filling the blanks, which I've done 10 years ago. But I'm just saying, I thought it'd be the easy way out. It's not though. Now when you get bigger and bigger,
Right.
you gotta have a
Right, exactly, because
it's just, you know, it just gets more complicated.
absolutely.
And then what happens is that it might just come back at you.
Sometimes, you know, people get away for a while. They
Yeah, for
get
a
away
while,
for a
that's
while. And then when the terms, something goes
Ah,
wrong,
my mother.
okay, what do we do now? We gotta look to the contract to see, oh, I didn't know that was in there, I didn't understand that, and so now it's damage control, because now we have to try and look at this contract and see how we can frame it to be your defense and most favorable to you, and how you can argue that, you know, it should be interpreted this way versus that way to win, you know, and by the time you spend all the money going to court to try to, you know, fight over what the agreement, it's always best to know, have it sit down, have it explained to you, and understand what these terms are, especially again, if it's a big contract of value, you know, small things, cars, you know, things of that nature.
Contractors, we go, like, let's say, I'm the lowest bidder, so I get a bid up to $500,000. And they give you this contract about this big, and they put their own writing in there though. And if you don't read it, like, let's say you drop out of the damage, you mess up the schedule, it just takes all your money right there, I mean, so.
The slightest little, they don't really know, the slightest little breach or the slightest little, something that
Just
you
the
think.
language, I mean, because I do it, I have a lawyer who reads my contract, but just the language, just twists around, it can mean this, can mean that.
Right, well, you thought it would mean,
Yeah,
it meant this, but legally it
Legally,
means something
something
else.
else,
And
yeah,
like, oh my gosh, if I'm sick and I don't do this,
Yeah.
I can, you know, I can breach this contract and they can take it away and they can replace them with their own workers, or they can do this.
I mean, in construction, we learned the GCs, they want to, they're there to squash you or give you less as you can. If you don't fight back or know what you're doing, they're gonna do.
And they won't pay you, you
They
know,
won't
and
pay
they'll
you.
say,
And that's what they do, you know, I mean, that's what it is.
Yeah.
So if you're gonna, so.
all the workmanship wasn't the way we wanted, or this wasn't that way, or we said this and you didn't deliver this on time, or you came at this time and not that time, and they will try to, you know, reduce what it is that you bid for.
Only reason because they know they can do it. Once they know you know what you're up to, they're gonna, they're gonna think twice.
Absolutely.
And that's what you learn, hey look, let the lawyers do the work, let the engineers do the work, I mean, that's all right.
And a lot of time, when they know that you have a lawyer reviewing the
Yeah, yeah,
contract,
yeah.
they make sure
Yeah,
that
yeah,
you're,
that's what I look
just
at,
in
yeah.
and of itself, just to know, if they know they're dealing with you as an individual, okay, this is gonna be a piece of cake sometime.
And I'm only talking because we do big contracts sometimes, that's what I'm talking about, I'm not talking about little stuff.
Mhm. Yeah,
You know, I
absolutely.
mean, that's what I'm talking about.
Mhm. And the big contract is where the money is, so
That's
that's where
where
you
the-
wanna make sure you protect your engines
100%.
and you protect, cause you could do all this work and you did something.
And I want to tell you, I did about 3 or 4 companies go out of business that way, they just squashed them. And then, you know, that's where it was.
And they don't have the money to fight.
They don't have no way to fight it yet, so it's.
Generally speaking, what does a firm your size charge for creating a business-to-business contract?
What do you mean when you say business to business? Like one business negotiating?
One business offering a product or service to another business,
Mhm.
but you want to have a business you're selling to sign a contract because you don't want them, you may have patent, you're giving them a patent product, you don't want them to copy or use that. You know.
Trade secret, things like that.
Yeah.
Mhm. And who owns the intellectual property, that gets, when there's intellectual property rights and things of that nature, that gets more involved. And you will find that law firms typically charge an hourly rate. Our hourly rate, it depends, it's typically $200 an hour. The bigger the law firm, the bigger the hourly rate, to be quite honest with you. You have some law firms that charge anywhere from $250 to $350 to $400, you know, and the more experienced they think that the lawyer is, the more they build them out at. So that doesn't mean that
So that was a very vague answer because I don't know how many hours it takes to write a contract. Since a lot of it's already boilerplated, but you gotta add.
you gotta tailor it specifically
tailor
to
it,
your
so,
situation. And it depends, you know, we're speaking generally. So if you say just a business to business, you can be buying a business, and then that entails a lot because you have to make sure that that business is thriving. You have to, you request
Now, this is a product or service
that you're just selling.
being sold with proprietary elements in it.
It can take anywhere from 2 to 3 hours. It can take, you know, 2 to 5 hours. And at that, say a 5 hour, because remember, you're drafting it, but you're negotiating. So you really can't put because if the other lawyer that represents the other party says, look, my client says no, and we're negotiating back and forth. They bill for we bill.
Yeah. So there's not gonna be, you know, another party, because it's my business, I'm creating a contract
Oh, I got you.
that
Oh, just a standard contract that you will
Oh, I
use
see what you're
for
trying to
all.
say, so you're gonna put your own, you got the plate, but you're gonna put your own terms in there. I mean, you're gonna do it.
And you're gonna shop it, so it's one contract that you have for your business, and when
Yeah.
you go to sell your goods, this is the contract that you will be
Yeah,
presenting
right.
to their business. Usually anywhere, that will probably be about $250 just to cover everything, and it's just one, usually it's a flat fee, it's not an hourly fee if it's something like that. And I say usually because I can only speak for myself, I can't speak for other lawyers, because again, it just depends on how much they think that they're worth. If they think my time is worth $500, that's what they're gonna charge you.
Oh, I've worked with some big firms.
Yeah,
I know.
so, absolutely. Any other questions? No? Okay.
Very nice.
You got it?
I do.
I have one, two, four.